yourself in the chat, your name and your company. We will be recording this webinar today as well. So I've just started that. So hi everyone, my name is Amy Mandryer. I'm with Project FoundED. I'm the co-founder and chief operating officer. My co-founder is sick today, Sandro. He was planning on joining us, but he's unable to make it, so I'm stepping in for him. At Project FoundED, we're focused on equitable outcomes for all learners by removing barriers to EdTech innovation and adoption. And we do that through a number of ways. The primary way being focusing on creating a community of EdTech entrepreneurs and then providing resources to help accelerate those organizations to help them accelerate their impact that they're having. So thank you all so much for joining us today. Today's webinar will be focused on COPPA and more specifically on a policy statement that was released by the FTC earlier this year in May, and kind of what does that really mean to all of you as EdTech developers. We've got a really brief kind of overview plan. We're going to focus this mostly on Q&A. So if you have questions, you can please enter them in either chat or Q&A, probably Q&A, since we'll have a lot of activity going on in the chat. So you can use the Q&A feature to ask any questions that you might have. So we'll set the stage briefly for you. So in May, the FTC released a new policy statement, and we started to see a lot of different articles in the newspaper about what this might mean. And whenever EdTech's in the headlines, we always like to try and see what kind of information and resources we can provide to you all. So we reached out to our network and were able to connect with Matthew Johnson with Cooley, who's here with us today. And he can speak much more intelligently on all of these topics than I can. I have lots and lots of questions, as I'm sure you all do. So I will turn it over to Matt to introduce himself and briefly talk on COPPA. I'm sure many of us are familiar with it. So just briefly kind of set the framework and the stage for this policy statement, and then we can kind of dig right in on what this latest information means. So Matt, take it away.
Great. Thanks, Amy. So hi, everyone. Good to be here. And just to talk a little bit about COPPA. First, just a really brief intro. My name is Matt Johnson, and I'm an attorney in Cooley's education and EdTech practice, which means that I just work with companies, investors, and others that are in the education space on a number of issues, but probably not surprisingly because of sort of where there's always a lot of focus. Privacy is probably one of the things that is top of mind with a lot of our clients. So a lot of that is how I spend my day, advising on a variety of state, federal, and international privacy laws. And obviously, COPPA and children's privacy has been top of mind for at least a couple of years, as the FTC has been looking to decide whether or not they want to make changes to COPPA and its framework. But most notably since May, when they issued this new policy statement. I know that a lot of you have questions. I think we're better off if we spend most of the time addressing those questions rather than me just talking. So I thought I would start by giving just a quick 5-minute overview of what COPPA is and who it applies to and what you should be thinking about with that and sort of what this new statement means. And then we can go from there into the question. So COPPA is actually two things. One is a statute that was passed by Congress in the 1990s, which sets out a basic framework around the protection of children's privacy and imposes on the operators of online services, so websites, mobile apps, any online service, commercial service provider, an obligation to protect the information, personal information of children under the age of 13. And so that's an important dividing point when it comes to thinking about how COPPA applies to what you're doing. If you are operating in a framework where you're not really involving children under the age of 13, then COPPA may not apply to you. If that is a focus audience for you, then it does. And there's been some talk around changing those. There's a proposal currently that would raise that to 16. So all that's sort of, potentially open for changes down the road, but that's where it currently stands. And then there's the COPPA rule, which is the FTC regulation. So the statute put the FTC, the Federal Trade Commission, in charge of enforcing COPPA, and they imposed their own rule that kind of builds out a more detailed framework around how COPPA should be applied. And it is an important, I guess, point to highlight how COPPA is enforced, because it makes it very different in practice than a lot of other privacy laws. So the main other education privacy law in the US is called FERPA, the Family Educational Rights and Privacy Act. And if you operate in schools, it's probably one you're very familiar with. A lot of schools are rightfully very sensitive to it. But one of the biggest criticisms of FERPA has been the lack of the ability of the Department of Education to enforce it, because it has a very limited tool set as to how it can force it. And it can't enforce it directly against online providers, and it can't issue fines or anything like that, which has made FERPA largely toothless. It's something that obviously is important to care about from a reputational perspective, but from a government enforcement perspective, there hasn't really been much. COPPA, on the other hand, is enforced by the FTC. The FTC is an agency that is really built for enforcement actions, and is charged with enforcing this. The FTC has a very wide-ranging mandate to generally protect consumers from a variety of different angles, and privacy and data security is one of those. And so that distinction makes it sort of inherently a much more likely regulatory issue that companies might encounter than otherwise. So COPPA applies to companies that are either targeted toward children under the age of 13, or even if that's not really where they're focused, if they have actual knowledge that their services are being used by children under the age of 13, you're subject to COPPA. And COPPA has really a couple of different requirements to it, one of which has really changed. And so the most well-known requirement under COPPA is that if you're subject to it, if you do collect personal information from children under the age of 13, you need to first obtain verifiable parental consent. And this is probably the biggest component of COPPA that companies that are subject to it figure out how to adopt, and do so in a way that satisfies the COPPA rule requirements without creating too much of a burden on users that would discourage them from signing up for the service. So navigating that is one key component to COPPA compliance. And that applies just to companies that are essentially operating on the consumer level or not operating in schools. For at least the past 20 years, the FTC has taken the position that if you are a company that is operating in schools, in other words, your customer is the school, not the parent or the child, then you don't need to get this individual verifiable parental consent before collecting personal information. Essentially, the school is essentially providing that consent on behalf of the parent and student. And I think to some extent, a lot of companies that are in that space, they operate the schools. At least the FTC has felt that those companies have misunderstood what this actually means and interpreted this to mean that they are exempt from COPPA entirely. But that's not really sort of the full picture of what COPPA requires. COPPA also requires that companies, one, have a pretty robust disclosure statement about the types of data they collect, how they use it, who they share it with. and then also place limitations on that data collection and use and retention to focus on essentially providing the services to the children. So COPPA prohibits the commercial use of personal information of children under the age of 13, and it prohibits companies from maintaining that data beyond the main purposes for which it was collected. So in other words, providing the service. And COPPA also has not very specific, but kind of aligned with other FTC data security obligations. It has its own obligation for companies that are subject to it to provide commercially reasonable data security so that they are following essentially industry norms when it comes to protecting the personal information that is being collected. So there's a number of different things we can talk about. I do want to stop there to kind of just get a sense of what companies are most interested in, and we can talk a little bit about what sort of information is subject to COPPA. Like when we say personal information, what does that actually mean? We can talk about what does it mean to get verifiable parental consent. We can talk a little bit about, well, what if I'm not sure if my my site is targeted toward 13-year-olds? What if my main audience is, call it 13 to 16, so it's like adjacent to that? What do I do there? And then we could also talk about sort of some of the other things about data minimization and data security. I don't know. I see there's some things going on in the chat, but I don't know if there's any questions to start off, or I can just start kind of running through some of those if not.
I have kind of a broad question to just kind of kick us off, which is just like pertaining to the guidance that came out in May, or the statement in May. It felt a little bit more like just a reinforcement type statement, and so can you talk a little bit about what your thoughts were when it came out, and then anything that you've seen or anything that you've seen in the recent future that might indicate a shift in direction or a change of behavior on the FTC's part?
Yes, so you are correct. So the statement itself, the policy statement, did not change anything. It just emphasized the importance, and reminded companies of the importance of complying with COPPA, and particularly was focused on these other requirements beyond obtaining verifiable parental consent. So making sure that you're minimizing the data you're collecting, limiting how you're sharing it, limiting how long you're retaining that information, meeting those data security requirements. So it emphasized those other requirements that apply to anyone who's collecting children's information, regardless of the setting. And then it also announced a renewed focus by the FTC to start enforcing more aggressively those requirements, and particularly in the EdTech or education sector. There has been a lot of criticism and also just sort of analysis that's been done that has indicated that enforcement has relatively been light. There have been a few sort of notable enforcement actions that have happened in COPPA, but not too many of them. And what this policy announced is that's likely to change. And so you should expect to start to see more companies getting inquiries. So the FTC has pretty broad investigatory power. So it doesn't necessarily have to say, we think you violated something. They have the ability to just send out sort of a notice and say, we just want you to answer these questions and, help us kind of do an assessment. And I think those sorts of things, those sorts of reviews are going to become much more common. And we've already started to see a few of those start to happen since May.
Okay, thank you. That's interesting. We do have a question in the chat, so we'll get to that first. And then those of you who have questions, please start entering them in Q&A. We'll also monitor chat, but Q&A will be a little bit easier for us to kind of keep track of. So the first question, I'm not sure if you can see that one, Matthew, in the chat from BeaKid. They provide a back office suite for service providers who offer after school programs. So the clients or parents register the kids into the program and put all the info like names, ages, birthdays, but they don't take phone numbers or email addresses, and they want to know if they're still on the hook for being compliant. So parents.
Yeah, so that actually raises an important, so COPPA applies to personal information collected from children, not about children. So if you're collecting the data only from parents or teachers or some other adult that's actually providing you the information, then it wouldn't be subject to COPPA. Now, where that can get a little bit sometimes fuzzy is if you're providing an online service and the initial registration information comes from the parent, but then you're going to combine that with user data that's collected from the child. That kind of then subjects that whole thing to COPPA, because now that user data combined with the registration data makes the whole thing personally identifiable. But if it's just like purely we're collecting information from the parent, then you wouldn't be subject to it. But if you're going to combine it, then as part of that parent registration process, that's where you would get the parental consent for you to collect all of it. I don't know if that fully answers the question. And one other thing to note, I'm not sure of who all the attendees are, but I meant to mention before, the other sort of key sort of initial gating item is COPPA only applies to for-profit entities. So if you are a nonprofit, you're outside the scope of COPPA because the FTC does not regulate nonprofits.
Great, awesome. Why don't we move over to the Q&A then? I don't see anything else in the chat I'm sorry, yeah, I don't see anything else in the chat for us. So do we want to move over to the Q&A? Let's see, so the first one.
Yeah.
If you know a child under 13 will use your platform, but you put a disclaimer up on a sign up saying you must be 13 to use the platform, otherwise have your parent sign up for you. Does that exempt you?
So, yeah, so it does not exempt you. So so that's where the two key things about determining whether or not COPPA applies to you are, one, if your audience is targeted for children under the age of 13, or if you have actual knowledge that children under the age of 13 are using it. Now, disclaiming it and saying that it's not, that they're not allowed to is not enough of itself to say that you're no longer covered by COPPA. Now, what has been set up is essentially the best practice to deal with. So like, let's say you in fact just decide we don't want to have to deal with this parental consent process. There's a process that's been recommended by the FTC, and it's not necessarily the only practice, but it's the common sector way of doing it, which is age screening users as they register. So as they register, you collect a date of birth from an individual, and you're supposed to do it in a neutral way. So the person who's filling it out isn't being, it's not just a checkbox, are you over the age of 13, yes or no, it's please provide your birth date without sort of any hint as to what the right passing answer would be. And ideally, you're collecting this at the front end of any other information collection. So the first step kind of they're going through is please provide a date of birth. And if they pass the age screen, then they get to continue on with the registration. If they fail it, then they are told, sorry, our services are only intended for children under the age of, over the age of 13 or 13 and older. Please, sign up, later, when you're older. And then best practice beyond that is if someone fails the age screen, you would then place a cookie on their browser that would prevent them from going, immediately back, and typically have it last for at least, 24 hours is kind of considered the standard, before they can go back and, kind of retake the test and give a non-truthful answer. And that's not obviously foolproof. Someone could still get through there, but that is the level of effort that the FTC has said, if you take those steps, And then if it comes to your attention down the road that someone under the age of 13 is using it and they lie to you, that you would remove them from the platform, that is sufficient to kind of meet your obligations.
Great, thank you. If there's a follow-on questions, please go ahead and enter them in the chat. We have a couple of questions around what actually is personally identifiable information and how, is there a list of what defines that, or it is, just getting the year of birth instead of the full date still considered personally identifiable information? Do you have any advice there on how to determine what data is considered PII?
Yes. So COPPA has a relatively broad definition of what they consider to be personal information. So it sort of expressly includes, obviously, like the basic things that you would think of: name, physical or email address, other online contact information, telephone number, any sort of thing obviously like a social security number. And then one other thing is if you are collecting any sort of persistent identifier for like a device ID or an IP address, that would then be able to track, the usage back to create a profile essentially of an individual. Any of that would be considered to be personal information. And I should also note that this applies to information about the child or about their parents or family members. So even like if you're collecting a parent's name and email address, if you're collecting it from the child, it's considered personal information subject to COPPA. And then there's sort of this broad catch-all that, it includes like any information that when combined with other information makes it personally identifiable. So I think the one question was about year of birth. So, year of birth probably by itself is not reasonably identifiable, but you would also need to think about, are there other things that you are collecting that you would combine with that make year of birth identifiable? And so there's not sort of a one size fits all answer there, because it depends on, typically if you collect, if you collect a bunch of different pieces that are generally non-identifiable, but you're then tying all of that back to an IP address, it then kind of like has this effect that it makes everything identifiable then.
Great, thank you. Okay, shifting gears a little bit. Some questions around a couple. Is there a standard student data privacy agreement? Any sort of templates that exist out there?
There is no one template. There is, so if you are contracting with schools, most states now have their own student data privacy addendum or agreements that would be supplemented to any like agreement you enter into with a school. They all are a little different. Most of those are required under state law. COPPA does not require there to be student data privacy agreement, so there is no federal like uniform form. I will say that the forms, they vary some, although they have a lot of similarities between them. As with a lot of things, particularly in privacy, California tends to set the high bar. And so from a practical matter, most of the most stringent requirements are going to be found in the California form. And if I could probably actually pull up here the link, I can put it in the chat here. So that everyone can maybe just take a look at it. It doesn't just cover COPPA. In fact, I'm trying to think how closely it actually even addresses COPPA directly. But it's mostly focused on state laws. which do that, but I'll put this link in the chat here. And that way, and so if you go to this link and you scroll down to, if you just look down to the bottom of the page, data privacy agreement, that'll give you an example of the California one. And so that's a pretty good example of the sort of agreement that you would enter into with a school. But it does go beyond COPPA. It'll address California student privacy law and others as well.
Great, thank you for that. And this is sort of related, but there's two different questions about, but sort of related, a vendor and the schools coordinating parental, verifiable parental consent. So can you talk a little bit about what that industry standard or best practice might be when it comes to verifiable parental consent?
Yes, and I'm just seeing also in the chat that maybe the link didn't, I can see the link. I'm not sure if anyone else can see it in the chat. I'm not sure if that's disabled or not, but we can get you the link.
I will copy it over. I've got it.
Okay. So, yes, yeah, it goes my error there. So yeah, so going back to sort of coordinating on parental consent between the school and the vendor or provider. So the FTC has been pretty adamant that you can't shift an obligation to get parental consent from the operator of the online service to any other third party. So you can't say just in your contract that the school is responsible for this, or let's say it's not a school, let's say it's like an after school center or a daycare or something like that. You can't shift your COPPA obligations to that third party, at least as far as the FTC is concerned, right? So like that wouldn't, if the FTC were to investigate and they were to come and say, you didn't satisfy COPPA, you wouldn't be able to say, well, we told the school they were responsible for doing that. That wouldn't be like an acceptable reason for them, because it's your obligation as the company. Now, what is important in the school context is individual parental consent is not required in the school setting. So if the student is using your service because you have an agreement with the school, then individual parental consent is not required under COPPA. You're allowed to essentially presume that because you have this agreement with the school. It does not change your other COPPA obligations, which is actually the main focus of this guidance that just came out in May. So you still have to have, essentially a detailed privacy policy that parents could look at and see, what obligations, what your privacy practices are. And then you still have the obligations for data minimization and having a strict retention policy. But I'm not sure if that sort of fully answers the question, but that's, really, it's not so much that you're shifting or working with the school, it's just that you don't have to get parental consent, but still have to meet all the other requirements.
Right. Okay. I think I think that answers the question. If anyone has follow-on questions, please feel free to enter them. And that feels like good news, at least one less thing potentially that everyone has to worry about as it pertains to taking care of this. Okay, so we have a couple questions back on nonprofits. One is just, where can we find in writing where nonprofits are exempt from COPPA enforcement? Is it because the FTC doesn't oversee nonprofits?
Yeah, I don't know. They might specifically address it in their FAQs. Yeah,
I can drop the FAQ.
Yeah, that link is probably helpful too, but they do say it. So yeah, they do address it in this FAQ, and I'll put it in the chat here. I think I'm sending this to everyone. But yeah, I mean, so basically COPPA itself, the statute says that it applies to commercial websites and online services. And that's also in line with like the scope of the FTC's jurisdiction. Now there could be exceptions to that. So like a nonprofit association of commercial entities could be subject to the rule. There's been some like case law around that, but if you are operating as a kind of straightforward nonprofit, then it doesn't apply to you. Now, just because COPPA doesn't apply to you doesn't mean that there aren't other privacy obligations that apply, particularly at the state level. But the COPPA and the FTC's enforcement of it would not apply.
Great, that's interesting. So there's a question that goes a layer deeper. So I think if I'm understanding it correctly, if your customer is a nonprofit organization, the nonprofit then works with students, how does that perhaps change the difference between contracting with schools?
So if you are collecting personal information from children under the age of 13, and you don't have an agreement with the school, it can get kind of complex, because I guess it would depend on like exactly how that was coming, and like, are you actually collecting the information from the student, or is the nonprofit collecting it from the student and then sharing it with you, which is a different framework, because COPPA only applies to data you collect from children under the age of 13. So like if that was being done by the nonprofit and they were sharing it with you, then that might not subject it to COPPA. But if you don't have a direct agreement with the school, you would need to assess if you are collecting it from children. And if you do, then you would need to obtain verifiable parental consent. So like the most straightforward situation that like we could see this happening would be, let's say you have an agreement with a youth center, or a recreational camp, or a daycare, or like a church or something like that. None of those would like allow you to take advantage of the school exception, even though they are nonprofits. If you were the one collecting the information, you would still be subject to COPPA, still need to get verifiable parental consent.
Sorry, I was on mute. We have two specific questions. So if the data that's being collected doesn't have any unique identifiers or used for research and product improvement, does that exempt you from COPPA? I don't know if exempt is the right word, but.
Yeah, so I mean, so COPPA applies to any provider who is collecting personal information from children under the age of 13. And so if you are not collecting any personal identifiable information, then COPPA wouldn't apply to that. But I think that's like, I think it is worth like digging into the weeds as to when you say, student data without unique identifiers, like what are the specific elements you're talking about? And then kind of taking a step back and say, when you look at those and you look at sort of all of those that are collected, does it become like, is it reasonably certain that you could identify an individual by collecting those data elements? And that's sort of like in the context of what other information is personally available. So one statistic that I've, that is kind of thrown around a bit in the privacy and data security world is that if you know an individual's, I think just their first name, their year of birth, and their zip code, you can identify a very significant number of people. Not everyone, but it's like even just for those 3 data points, none of which are individually identifiable, you could probably identify, 75% or some very high number of people. And so that's sort of like the analysis you have to kind of put to it is are these data elements that we're collecting, even if they're individually not identifiable, when I combine them, are they still not potentially identifiable?
That makes sense. The other specific question, which is also along the lines of personally identifiable information, is a child's voice considered PII, and does that fall under COPPA or perhaps some other privacy law?
So their voice, that's a good question. I actually don't know off the top of my head. I'd have to look if voice is covered. I know, like, obviously, like their picture or likeness or an image of them or a video recording of them would be personally identifiable. But that's different than their voice. Obviously, I guess it would depend on like what are they saying, right? Because they could be saying, like, if their voice itself might not be personally identifiable, but if what they say is personally identifiable, then it would become that, the recording, that data would become personally identifiable. I would think probably of itself voice isn't, but you could see how it could bring in personally identifiable information.
Yeah, I think in this case she said it was the name, so that would be maybe just a first name, but if it's more than that, then it would apply.
Right, and like if you're combining that name with, also we're tying that name to this IP address, or we're tying it to some other piece of information, then that it might become person identifiable.
Yeah, and it still applies, just to like further clarify, because it's in here, it still applies if just the school and the teachers have access to that data. It still applies.
Yes, so if you collect this data, regardless of how you're using it, COPPA still applies. It's helpful if you're using it, like if only teachers or school personnel have access to it, because there are these other obligations when it comes to like restricting who has access to the data. But big picture, COPPA still applies to it then.
Okay, great, thank you. Okay, a question here. Many EdTech providers utilize other organizations for single sign-on, like Google or Clever or another system. So if you offer single sign-on using a reputable provider, can you leverage whatever they've already done with regards to the COPPA verifiable consent and the way that they're keeping the data to ensure your compliance, or any best practices or thoughts there?
Yes. So yes, you can. So you're right that most of those providers have made a decision that they only want to have users over the age of 13 and avoid having COPPA obligations. And so they've developed a process. I think actually the first use of the age screening that I talked about before was for creating YouTube accounts. But that's been sort of like the system that's been applied. So like most of those providers are doing that. Now Clever is a little different, right? Because Clever integrates with the school, and so it's sort of like inherently designed to be used by children under the age of 13, as compared to like generally Google and others. Now, I'd want to know, because I think Google Education and their like classroom integration, there might be a way like that's set up so that children under the age of 13 can use it. But if it's more of like their standard Google account, and it's not a child's account, and like, so I would say you want to do a little bit of looking into the single sign-on process that you're using, does the process in order for someone to get to that point to be able to use their Google or whatever account require them to pass like a COPPA certified age screen or not? And if it does, then you can rely on that, because that's what it's designed for. If it doesn't, like if it's something that anyone could sign up for an account for, then you couldn't.
Right. And then any data that you would collect after that point, such as an additional date of birth or additional personally identified viable information, would be your responsibility.
It would, and that's where you would need to decide, like, if your decision was like, even if we're going to utilize a single sign-on for other reasons, but we don't want to have COPPA obligations, you could decide like that you still impose your own age screen or something like that to try to deal with that, or you would just decide that you would be subject to COPPA if you were okay with it being open to children under the age of 13.
Cool. I have a question that's been upvoted a couple of times here towards the bottom, so we'll do that first, and then we'll kind of close with some of these higher level questions. So many EdTech providers make arrangements directly with teachers, perhaps sell their products directly with teachers, or get started with free pilots directly with teachers. So where does that leave us with verifiable parental consent?
So it's a great question. It's one of the questions that I probably get most frequently. And unfortunately, there's kind of a squishy answer to it. So the exception to needing to get verifiable parental consent in schools isn't found in the statute or regulation itself. It's only found in that COPPA FAQs that Amy has linked here, that sets out sort of kind of like the more detailed in the weeds requirements. That's the only place it's found. That's always been a little concerning for people because, like, in theory, at least the FTC could update that web page and take that away. Now they probably really couldn't because there's court cases that say they have to give everyone notice and things like that. But it's not the same level of burden if they did want to change that policy as if the statute needed to be changed, because that would require Congress, or even the regulation requires a much more detailed process. So there's always been uncertainty as to like the exact boundaries of the school exception. And in fact, even this is kind of maybe a bit too like legal nerd sort of in the weeds, but states can also enforce COPPA. It's mostly enforced by the FTC, but state attorneys general can also enforce it. A lot of them have sort of overlapping jurisdiction as the FTC. And there was a case involving New Mexico where at least at one point New Mexico took the position that just because the FTC said that there was this school exception didn't mean that New Mexico had to accept it when it was enforcing the statute, because it wasn't in the statute itself. That got settled. They never really pursued that. Who knows? It seems pretty likely that you can rely on it. But what the FTC has said when it comes to teachers is just, we're not going to tell you you can't rely on a teacher. We're going to just say that we don't think that's best practice. And then you kind of have to apply that using your own judgment and risk tolerance. So there's a number of sort of variables that could impact it. One of which is, does the teacher actually have the authority to enter into the agreement with you on behalf of the school? Just like, I can't probably bind Cooley to anything that I want to just by signing it. There's a process internally that you have to get approval for that. That's even more so the case at schools, which are government entities, which say, teachers might have authority to enter into agreements below a certain level, but not above a certain level. Then it has to be the principal or the superintendent, or there's a number of different internal processes. And because they're the government and they get to write their own rules, they can take the view that even if you thought that they had the authority, but they actually didn't, then you couldn't rely on it and the school can't be bound by it. So, all of that's like a really sort of a non-answer to say, no one has said that you expressly cannot rely on teachers, although it definitely creates more risk because of all of these variables that could potentially, either the state or the district or the FTC could say you weren't reasonable in relying on it given the facts and circumstances.
Great, thank you. Okay, then next question actually has a lot to do with something that caught my eye earlier. I think earlier this year, Warren and Markey last year conducted an investigation and then came out with a report earlier this year where they were primarily looking at student activity monitoring software. And I'm just curious if their sort of concerns about surveillance. The question here is that this organization is not collecting any personal information, but they are collecting the online activities of the students. So where does that fall kind of in the privacy landscape that we should be thinking about?
Yeah, no, there was a lot of attention focused on that report. And I know leading up to it, they had conducted a pretty extensive investigation and asked questions of different EdTech providers, particularly, monitoring, software monitoring providers. So it's a bit like aside from COPPA. So there's really sort of no current sort of legal question as to whether or not a school has the right under COPPA or any other law to utilize a device monitoring program or something like that. And the main, I think, purpose of the investigation and the report was to raise other potential legislative questions about, what sort of disclosures, if any, should be mandated around that, what sort of opt-out rights should be given to parents, if there should be limits around that. None of those which are sort of implicated by COPPA. But then the report itself did also kind of bring in COPPA questions about, COPPA is now 30 years old. It was created in the 1990s. It was last updated in the early 2000s. Senator Markey was sort of the original, I think he was the sponsor, but the drive behind COPPA when he was in the House. And so, it could make sense that there could be an interest there in looking to update it. There's another act that's also pending in Congress by Senators Blumenthal and Blackburn, which also would look to make updates to COPPA. I don't think any of them are looking at taking away this school exemption that we've been talking about. There's been, there's obviously some groups that think that takes away, rights from parents to be able to make those decisions. So you could see some modifications of it or clarifications around when it applies, parental opt-out rights around that. But I don't think it's going to go away. It's, it would make things pretty unwieldy for schools to work with technology vendors if they, didn't have kind of a clear path on how that would work. But I think, I do think this is a space that if I was going to guess, is there going to be an update in the next 6 months or a year? I would say it's unlikely. Is there going to be an update in the next 5 years? That's probably a much stronger bet. I think that there's a pretty bipartisan recognition that this law needs some updates, and there's some generally rare agreement on some of the things, at least around how improvements or strengthenings of the law could be made. And anything that has that sort of level of bipartisan sort of agreement in the current political environment is rare, and it increases the chance that things could get accomplished because you could find ways to agree. Although this year it's still an election year, and the likelihood of anything getting done in the next 6 months or so before the election or immediately right after is pretty unlikely. And I don't think anything's going to happen quickly. So I'm not advising clients generally to hold off and wait and see what sort of changes could be made, or do or not do anything based on what might or might not get passed. I think that there's going to be an implementation period, whether it's congressional changes, whether it's the FTC making changes to the rule itself under its own authority. They have indicated an interest in doing that. They've sought public comments about that. But none of that is moving quickly enough or is going to change things enough that you should hold off and sort of complying with the rule or kind of thinking about what it means for you as it stands today.
Great. Thank you. Okay, we have one question left at this time, and we're nearing the end of our time together. So I'm wondering if you could just summarize at the federal level the different laws or acronyms that we need to be aware of as it pertains to data privacy.
Yeah, so there's a lot of them, and they are all confusing acronyms, but so if you're collecting children's data for children under the age of 13, COPPA should be at the top of your list. It really is the most potentially impactful law applicable to you. The only other real student privacy law at the federal level that's out there is FERPA that I mentioned at the start, Family Educational Rights and Privacy Act. It is even older than COPPA. It was passed in 1974 and has been only minimally updated since then. It's not really a major enforcement. There's not a lot of enforcement behind it, but it is very important reputationally, both to providers and schools, to make sure that they are structuring their agreements and their data practices in a way that complies with FERPA. So if you work with schools, regardless of the age of the students, and that's both K-12 and higher ed, FERPA is an important one. At the K-12 level, there are now almost 50 different, it might be a little bit short of that, 47 or 48 states have their own student data privacy laws. California, which is the one that's kind of set out in that data privacy agreement, the link that we shared, sets probably the high bar. So, companies often ask, like at the state level, how can I possibly focus on complying with, a different law in every state? And it is, it's not that there's a magic bullet to that, but the easiest answer is that you kind of look for the high bar of the states where you are operating in. And if you're operating in California, or you're just looking to do so, it typically sets the high bar. And so it's one to focus on, although you might have some nuances around some of the others. If any one state is really important to what you're doing, like if you have a pretty significant concentration of your business in any one particular state, I highly recommend that you take some time to get to know the state student privacy laws applicable in that state, and maybe spend some time thinking about if there's additional steps you might want to take focus specifically there. And then, if you're not operating in schools, but you're still focused on children, you're direct to consumer, whether it's COPPA or, under the age of 13 or older, also be just sort of aware of general consumer privacy laws. So there's both federal and state level general consumer privacy laws. And just because you're subject potentially to these children or student ones doesn't mean you're exempt from those other ones. So the high bar again is California. It's the California Consumer Privacy Act, if you're operating there. And it applies to anyone who's collecting personal information about individuals from California, as long as you meet certain thresholds as to the level of business you're doing there. And that's creating a trend where other states are following suit. And then, internationally, there's a real trend around that as well. The first sort of real robust personal data privacy framework was actually created in Europe around GDPR back in the mid 2010s or early 2010s when it was rolling out. So if you're doing business internationally, again, like if it's a material part of what you're doing, if it's occasional users and it's not really core to your business, in most cases, as a startup, it makes sense to focus on what really is. But if it starts to be more, you want to spend some time focusing on all those as well. They all have their own COPPA-like rules, but they vary quite a bit. Some of them are older ages or not. So definitely make sure that you take some time to look at those other jurisdictions.
Great. Thank you so much. Thank you for being such a sport. We did it. We answered all the questions.
Yeah, I'm guessing everyone is now totally set on COPPA and is good to go. So
and I shouldn't take credit. You did it. I didn't do anything.
No. No, but this was fun. Definitely, if anyone does have questions or anything that they want to chat about, I'd be happy to offline as well.
Great. Awesome. Well, thank you so much for being here with us today. Thank you everyone for joining us. And please, join us in Slack. We can continue the conversation there. And we will be sure to create many more opportunities like this one to provide you with information and resources to help you grow your business and your impact. Thanks so much. Bye.
Take care, everyone.